So welcome everybody to the June 29th Board of Municipal and Zoning Appeals zoning docket. My name is Katie Byrne, I'm the acting executive director. So if you tuned in a little earlier, you saw the board go through its general meeting item docket, and now we are getting ready to start the regular docket for the day. Just to explain a little bit on how WebEx works, if you have called in as an attendee, you are both muted and your video is off. So you cannot speak until I either unmute you or elevate you as a panelist. If you look at the bottom of your screen, you'll see a microphone and camera button chat feature. I ask if people would like to communicate to please use the chat, not the question and answer. You should be able to see the board and myself on the screen. When your case is called, and I elevate you, you'll be able to make your camera functional. We'll be able to see you. Attendees who call in and wish to testify. So if you are a call-in user, I will go through each call-in user. You will hear 2 beeps. If you hear the 2 beeps and it is the case that you're here to testify on, please speak up. If you do not say anything, I will move on to the next call-in user. If you're unable to connect to audio, please use the chat feature. If the speaker is unaudible, we will ask that you try to call back. There's 2 ways you can testify in support or opposition of a matter, and 2 ways you can let me know. Using the chat feature to put a message in the chat. Again, do not use the Q&A. And there's also a hand raise function that will let me know if you wish to testify as well. Order of testimony will go as follows. The applicant testifies first. Any testimony in support comes second. Any opposition third. And then the applicant gets the last word and the testimony closes. So it's up to the chair if they want to reopen any section of the testimony, but that is the order in which we follow. Anyone speaking on this matter before the board is assumed to be testifying under oath, and you are required to speak the whole truth and nothing but the truth. If you have any issues with WebEx, you can call our office and someone will be able to answer your call. Please do not email the office or email me because we will not be able to respond. The office number is 410-396-4301. Again, if you're having technical difficulties and cannot participate for whatever reason, please email those issues to bmza@baltimorecity.gov. And I will turn it over to the chair.
All right, thank you, Ms. Byrne. The chair will remain faceless today. We have some video problems, so that doesn't disturb anyone. The board will vote on each case and make a decision at the end of the docket. Those matters are. If you would like to stay online to hear those deliberations, you feel free to do so instead of participate. In any event, you can call the BMZA office tomorrow morning after 9 a.m. At the same number that had just given you, 410-396-4301. Should receive a resolution in the mail within 30 days. We ask that you not do any work until it is in fact received, and certainly we ask that you not do any work in Baltimore City without full minutes. Or at least 2 postponements on today's docket. Those matters will not go forward. For cases, case number 2021-094, 500 South Lehigh Street. The appellant on that matter is Sean Harvey, Esquire. That matter is postponed and will be rescheduled perhaps. Second case postponed today. It's on the docket. Case number 2021-096, 628 North Carrollton. The appellant there is William Brodus, and then 628 North Carrollton. So if you're here for either of those cases, they will not be heard today. Stay tuned for updates as to when they'll be set on the calendar. We have a slew of cases today that are on the consent docket. And for those of you who are unfamiliar, the consent cases are those cases for which the board has sufficient information to believe to grant the appeal. There's nothing we'll give the one last opportunity to add anything to the record that they wish. For all intents and purposes, those appeals will be granted. So I'll start at the top of the docket and go through these consent cases. First matter is case number 2021-023, 5345 Denmore Avenue. The appellant is Mariam Sovic Architecture. request to construct a new one-story community center at that location. Now, hear any reports we may have on this matter.
Okay, Mr. French, do you have anything on this one?
One moment, please.
Oh, certainly. I'm happy to go first. This is an application to construct a one-story community center. Let's see, this is variances for lot coverage, off-street parking, and the conditional use, I believe, as well, for the community center.
All right. I will try.
Oh, okay.
Martin French for the Baltimore City Planning Department. Planning Department has reviewed this application, noted that this proposed use and this site is consistent with the Arlington Inspire plan for that area and is recommending approval of the application.
And we have the applicant, Mr. Randy Sovich. Mr. Sovich, you are unmuted.
Okay. I could speak to the building. I'm the architect for the building. Pastor Randall, I believe, is on the call as well, and he could speak more directly to the use. But the building itself is going to be very consistent with a residential structure and the structures that are in the neighborhood as far as setbacks and side yards. They are smaller than the zoning, but they're not that far off from what's actually in the neighborhood.
Right.
And the height is, as a one-story building, is not out of line as well.
Right. Well, that's helpful, Mr. Sovich. And I was simply going to ask if there's anything additional you would like on the record. I believe we have, again, sufficient information otherwise to do what we need to do. But if we want for the record, you may feel free to do so.
All right, and we have Mr.
I don't believe there's anything.
Okay, and I've elevated Pastor Randall as well to a panelist. So Mr. Randall, Pastor Randall, just to confirm, your plan is to use this area as a community center and you're requesting conditional use approval.
Absolutely. Currently, we use services in the community, linking people to resources and supports. We run an annual summer camp, a golf summer camp, and we also have senior services. So to have this building and giving us a space to do it, right now we're just bouncing from place to place. It would give us a strong footing in the community to help in the community as far as neighborhood association meetings and things like that. We could really be a support if this building was approved.
Very well. Thank you for that additional information. If there's nothing else, then I'm happy to tell you that the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you very much. Good luck to you.
So very much. Thank you so very much.
Be well. Take care. Case on the consent docket, number 2021-049, 1401 East Pratt Street. The appellant is RKK, care of Daniel Brock. Request to construct 3 multifamily detached dwellings. There are 103 dwelling units total. Off-street parking. I'll hear any reports you may have.
Planning Department reviewed this application, noted that this site is part of the Perkins Somerset Old Town Plan revitalization effort. The proposed structures are part of that larger redevelopment, and the designs are currently being reviewed by the Urban Design and Architecture Advisory Panel, which is continuing. The department therefore recommends that approval of this application be subject to the condition that all improvements and landscaping are completed and maintained in accordance with plans approved by the Department of Planning. Thank you.
Thank you, Mr. French.
As Mr. French stated, this is part of the Perkins Home re-improvement. The specific requests are maximum front yard setbacks for building A, B, and C. In addition, rear yard setbacks from 12.83 is proposed. Front yard, corner yard setbacks, 5 feet is required, 3.82 feet is proposed. And let's see, I think we have Danielle Brock on the call. And I will elevate her to a panelist. Ms. Brock, you're unmuted.
Yes, good afternoon.
Good afternoon, Ms. Brock. We're here for 1401 East Pratt Street. And I'll ask you, is there anything you'd like to add to your application at this time?
No, everything that you have stated was correct. We're just asking for variance for the setbacks for the townhomes and the multifamily use building.
Very well. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you. Thank you.
Great day.
You too.
Right, next matter on the consent docket is case number 2021-085, 520 East Clement Street. The appellant is Jennifer Russo. This matter involves a variance to bulk regulations related to constructing a 2-story rear addition, 3rd floor addition, and rooftop deck. Now, here any reports you may have.
Planning Department has no comment on this application. Thank you.
For this one in particular, we have a minimum rear yard setback of 18.5 feet. Variance is requested. Maximum lot coverage, 12% is 92% is proposed, so it's a variance of 12% requested. It's interesting that let's see, I don't actually have a file for this one. Greg and I were discussing before, we thought there might be a postponement request that had come in. I did not see one in my box, so we kept it on the docket. So I'm going to see if Jennifer Russo or Haley Oloa are on the call. All right, I'm going to go through the call-in users. If we do not have anyone for this one in particular, we'll end up moving on. All right, so let's try the call-in users. If you are here for 2021-085, 520 East Clement Street, please speak up. All right, going to the next caller. 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 2 more callers, going to the next one. And last caller. Okay, so it is possible that this one requested a postponement, but it didn't seem to have, we didn't have it in the file. So we'll go ahead and move this one to another docket.
Okay, so that matter will be postponed. All right, next case on the docket, case number 2021-090, 2201 Duker Court. The appellant is Brad Valaire. This matter involves a variance to bulk and yard regulations related to removing an existing 96 square foot wood deck off the back door, installing a new 96 square foot closet screened in deck with a style roof. I'll hear any reports you may have.
Planning Department has no comment on this application. Thank you.
1 variance is being requested, minimum rear yard setback, 20 feet is required, 0 is proposed. The proposed deck will replace and enclose an already existing deck. So let's see, Susan and Todd Ledrewski, find you guys. All right. All right, I'm going to go through the call-in users. If you are here for 2201 Duker Street, please put something in the text, in the chat, and I will go through the call-in users. If you are again here for 2201 Duker Street, appeal number 2021090. Going to the next caller. Going to the next caller.
Yes, Brad was here. I'm the designer for the project.
Okay, for Duker Court?
Yeah.
Okay, awesome. Is there anything that you'd like to add to the application?
No, ma'am.
All right. Thank you. The board having heard the appeal for 2021-090, we believe we have sufficient information to approve that appeal. Thank you, sir.
Thank you.
Okay, case number 2021-091, 303 South Madeira Street. The appellant is Alex Coleman. And this matter addresses a request for variance to bulk regulations related to construction in addition at the second floor rear. Now here are any reports.
Planning Department has no comment on this application.
The variance is requested. It's a minimum rear yard setback. 25 feet is required. 0 is proposed. Maximum lot coverage, 35% maximum. 100 is proposed. So it's 65% variance request. I believe that there's a possibility that the existing structure does cover the entire lot. I have Alex Coleman here that I will elevate to make a panelist. And Alex, you are unmuted.
Hello, yes. Thank you, guys. Yeah, the property currently on the first floor, the property currently covers the entire property, goes all the way to the property line. So I just wanted to build a second story rear addition.
Okay. All right. Is there anything else you'd like to add for the record, Mr. Coleman, in support of your application?
No, thank you. The neighbor that is adjoining to me already has a property that goes back to the end of the property line as a second floor rear addition. So the property I'm proposing will be, in line with what's already been done on that particular block.
Okay. Well, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you.
It's number It's number 2021-097, 4360 Bel Air Road. The appellant is Janine McDowell. This request involves a conditional use, neighborhood commercial use as an office. Hear any reports you may have.
Thank you. Planning Department has reviewed this application, noted that this property is an end of the row property along Bel Air Road. The property has previously been used for a commercial use, that is a personal services establishment. The applicant is proposing to use that space as the office space. The department is therefore recommending approval of this application as it is allowable as a neighborhood commercial establishment use. Thank you.
Thank you.
Mirroring what Mr. French had to say, the request is for conditional use neighborhood commercial establishment offices. Prior authorized use from 2007 was for a barber beauty shop on the first floor. This is in R7. And I see I have Miss McDowell on the line. I will elevate her, make her a panelist. And Miss McDowell, you are unmuted.
Good morning, everyone. Good afternoon, everyone. I'm sorry.
Good afternoon, Ms. McDowell. Is there anything you'd like to add to the record in support of your application at this time?
No, everything was said is correct.
Okay, terrific. Well, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you
great.
very much.
Thank you so much.
Take care. Case number 2021-098, 1601 Portugal Street. The opponent is Julie Tice, and this matter involves a variance request to bulk regulations to first, second, third, and fourth floor additions, with fourth floor terrace to be used for a single-family attached dwelling. I'll hear any reports you make.
Planning Department has reviewed this application, noted that this property is located within the Fells Point Historic District. The proposed design for the improvements of the property are subject to specific approval by the Commission for Historical and Architectural Preservation. It is our understanding that the applicant is scheduling this for CHAP review on July 13th of this year, and therefore the final design will be subject to all of the approvals given by that commission. On that basis, the Department of Planning recommends that approval of the application be subject to the condition that all new construction and improvements of this property are completed in accordance with an authorization to proceed to be issued by the Commission for Historical and Architectural Preservation.
Thank you, Mr. French.
The project requests the construction of a first, second, third floor additions with the third floor terrace. The minimum, there are 4 variances required, minimum lot area variance. 60 square foot variance is requested. Maximum lot coverage is 20% variance is requested. Minimum rear yard setback. The full 20-foot variance is requested, and a maximum height of up to 45 feet is allowed with board permission. 40 feet is proposed. And I think the last authorized use is as a commercial storage and parking facility. And I have Miss Tice, and I will elevate her to a panelist. All right, so Miss Tice, I'm just going to unmute you. Miss Tice? All right, so it could be that what you're calling in does not have the sound. So I think we just lost Miss Tice. So I'm going to go ahead and try to go through the call-in users and see if she's on one of those.
Well,
So again, if you are here for 2021-098, 1601 Portugal Street, please speak up. Oh, wait, hold on, Miss Tice, there you are. Miss Tice?
Okay.
All right.
Yes. Hello.
Okay.
good afternoon, ma'am.
Hi.
How you doing? We're here on case number 2021-098, 1601 Portugal Street. And I'd like to ask you if there's anything you'd like to add to your application at this time.
So the only thing I'd like to note is that we are in the process of having the boundary surveyed, because as you can see, it's a really irregular lot. So we're just confirming that the lot actually looks like that shape. It shouldn't affect any of the variance requests, but the actual site may look a little bit different from what's proposed. And I just want to note that to you and you that we will provide, once I have that finalized boundary, I'll resubmit all of these documents for the record that will reflect the boundary a little bit more accurately once we have that information.
Thank you. We appreciate that. If there's nothing else, I can tell you that the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Fantastic.
Have a great day.
Thank you very much.
Moving on to case number 2021-123, 3414 Labyrinth Road. The appellant is Jeremiah Lehman. This matter involves variance to bulk and yard regulations related to the one-story rear addition. I'll hear any reports you may have.
Planning Department has no comment on this application.
So there's really only one variance that's required. It's a minimum interior side yard setback. 15 feet is required, 10 feet is proposed. So it's a 5-foot variance requested. I've got Mr. Lehman. I will make him a panelist. And Mr. Lehman, you're unmuted.
Good afternoon. Thanks for having me. Yes, I guess I'm the contractor, and I believe Mendel Reicher, who's the owner, is also on. What we're requesting to do is just, I believe the setbacks were changed a couple years ago. And the existing house is 10 feet from the side setback, and the addition that we are proposing to build, we're trying to keep that same line, so we have sufficient size for the addition. So yes, we're just requesting that we keep the same setback as the house, which is 10. And just one thing to note, I believe the appeal document, the address was transposed somehow. Or the application is correct, and I had sent in a request to, the address is 3914 Labyrinth.
3914 as opposed
Yeah.
to 3414. Okay, very well.
Yeah, and that was, I just believe, a typo on the agenda. Your application is correct. So yeah, that was definitely a typo on our end, and I've elevated Mr. Reicher as well. And Mr. Reicher, you're unmuted.
Hi, good afternoon. Can you hear me?
Barely, sir. Could you speak up or move closer to the mic?
Sure. Good afternoon. Could you hear me?
That should suffice, although it's still a little faint.
Okay, I'll speak as loud as I can. I just wanted to point out, first of all, thank you all for getting together to hear us out. I just wanted to point out that the addition that we're proposing is very much consistent with quite a few additions that we have in the neighborhood, which were made both before the zoning law in R4 was changed, as well as afterwards, obviously with a variance. We just want to build back flush with the present side setback that we have. The rear of the addition would be well within the rear setback. So we just want to build back consistent with many additions that we have in the neighborhood.
Okay.
All right, and we also have a letter from the neighbor at 3912 who are in support of the variance. And it looks like we just had something pop up in the chat. Let's see, from a Mr. Benjamin Steinharder, who said he'd like to testify as well. So I will unmute Mr. Steinharder. Mr. Steinharder, are you here for this particular appeal for Labyrinth? Mr. Steinharder? And all right, so he's not able to speak. And Mr. Harris as well. Mr. Harris?
I'm actually here for Hyson Street after this one.
Oh, sorry, wrong one. Okay. All right, so he's here for Hyson. So Mr. Steinharder, if you are here for this particular appeal, can you please put something in the chat? I just tried to unmute you again. All right, so doesn't appear that Mr. Steinharder is able to speak, and all right, so he's on the phone. So let's try the call-in users. All right, so we'll go through the call-in users. Oh, and I have another person in the chat who's in support as well. So let's start with the support. Hello, just unmuted you, Ms. Yakin.
Hello.
Yes.
Yeah, Johan Stein. Thank you very much for. Hi, how are you? You had read my testimony. I'm the owner of 3912. It's a semi-detached house, and we're the other half of the house, and we are certainly in support of the Reichers having the opportunity to do this. So thank you very much for considering it.
Thank you.
Thank you, sir.
All right, so we're going to go through, because apparently Mr. Steinharder is on the phone, so let's try to go through the call-in users. If you're here for Labyrinth Road, please speak up. Going to the next caller.
I'm here.
Mr. Stein?
You hear me?
Yes.
Steinharder. Yes.
Oh, Mr.
You
Stein,
hear
I'm
me?
sorry. Yes.
Yes, sir, we can.
Okay. Okay. Thank you very much for taking the time to hear this appeal. I also sent a letter in. I'm at 3916, which is on the other side, and I definitely would ask that this to get approved. We have no problem and no issue with it at all.
Very well. Thank you, sir.
Thank you.
Thank you.
All right, and I think that's it.
Okay, so my comment will be directed to all of you, but certainly Mr. Lehman, who's the named appellant here. The board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you very much.
Thank you.
Great. Have a great day. Good luck.
Thank you very much.
Great. That looks like it concludes our consent docket. Yeah.
Yes. All right. So did you want to move Hyson to the end and go?
Yes, I would like that. And in fact, can we take a 2 or 3 minute break? I have something matter that I have to take care of. But I shouldn't need a little bit.
Do you guys want to do one, come back at 1:40?
Sure.
Does that work? Okay.
All right. Thank you. Appreciate it.
All right. You guys will all be back on at 1:40.
Okay, I'm back. Thank you for that break. I appreciate it.
Okay. All right. I think the next one we were going to start with was 2021 100 1900 East Pratt. I just saw that there was a postponement request for this one. There were some posting issues. And we also have someone here on the call who was also going to testify to that. So I see that that came in yesterday. I just saw it just came into my inbox.
All right. So 2021-100 1900 East Pratt. They're seeking a postponement. All right. We'll call that case Shaheen Batmanglitch is the appellant.
Mm-hmm.
This matter involves a variance to bulk regulations to use for 6 dwelling units and off-street parking required. So I guess we'll get them on and do the postponement.
Well, I do not think they are not on the call at all. We have
fine.
someone, here in opposition based on posting issues. So
Okay.
Roxana was able to, I guess, catch that yesterday as well. So that one has been postponed.
All right, fine. It's case number 2021-100 1900 East Pratt Street is postponed on today's docket, pending remedy of those posting. All right.
Yes.
So we will pick up with case number 2021-101. The address is 516 North Arlington Avenue. The appellant is Omri Shitrit. This is a request to use the premises for 2 dwelling units. Variances are needed for off-street parking in a lot area. And I'll hear in the reports.
Thank you. Planning Department has reviewed this application. Noted this property is in the Harlem Park 2 Urban Renewal Plan area and also the Harlem Park community. This particular property, according to records available to planning staff, was last authorized for use as a single-family dwelling. The property is located in the R8 zoning district, and the zoning code does not authorize the board to approve conditional use conversions of single-family dwellings to multifamily dwellings in the R8 zoning district. And so the department's recommendation is disapproval of the application unless the applicant can indicate that the lawful multifamily use of the property is continuing. Thank you.
Thank you, Mr. Friend.
Staff recommendation mirrors pretty much exactly what Mr. French has to say. We were able to pull the land use card from 1962 that states that this was authorized as a single family dwelling. There has not been anything in Department of Housing Community Development records that indicate it has been used since 1962 as anything other than a single-family dwelling. The board does not have the authority to convert this to a multifamily dwelling. And you cannot even address the variances. So let's see here. We have Mr. Rainier for both this one and I believe the next application.
Right.
Right. Mr. Rainier, you are unmuted.
Yes. Thank you. My name is Frank Render.
Sir, we're going to ask you to speak up.
Yes. Can you hear me?
I can now. Were you able to hear the report from planning and also from Ms. Byrne regarding the history of this property being a single family, lawfully used as a single family dwelling, and your request for multifamily would require a conversion, and conversions are not allowed in R8 district?
Yes, I did hear that. And thank you for reiterating. I'm not sure then if I guess I can't really say anything about it. I'll have to look into.
If you had some information that would enlighten us as to how it became a lawful multifamily dwelling post 1962, that would be something we could hear and consider. But to the extent you have no evidence to provide to us today that demonstrates its use, continuous use as a multifamily dwelling, then the board is without authority to grant your request without even getting to the variances. It's not something we're in a position to do.
Okay. Yes, I unfortunately I do not have documentation on that at this time.
Okay. Well, and I think there's no additional testimony needed from anyone, and we'll resolve case number 2021-101, 516 North Arlington Avenue. While we have you, we'll move on to case number 2021-102, 600 North Arlington Avenue. Again, Mr. Citrid is the appellant. This is a request to use the premises for 3 dwelling units. Variances are needed for lot area and off-street parking. Formally, we'll just hear the report from staff and planning, but I think we'll be back in the same situation and we'll hear from you. So, any reports?
Planning Department reviewed this application. There was an undocumented record that this property was last used as a multifamily dwelling. However, it is currently vacant and the department is uncertain of the exact legal status of the property, but it appears from city records that the last authorized use was as a multifamily dwelling. To use this property for the number of dwelling units being sought by the applicant, which is 3, would require a lot area variance of approximately 10%, which the planning department did not consider objectionable under the circumstances. There is a requirement for also parking spaces to serve the units. However, this rear of this property abuts an interblock park, and therefore there is no rear access to any public street or alley that would allow use of the rear of this property for parking purposes for the use of the residents. The department is willing to recommend approval of this application if the applicant can demonstrate, as with the previous instance, that there is in fact lawful continuing multifamily use of the property. Thank you.
Thank you, Mr. French.
So of course we can't find the zoning card for this one. So we're continuing to look in the records, and this one we do not have the zoning card. It does show that in possibly 2010 that this was used for a 3 dwelling unit, but we don't have a use and occupancy permit. We don't have that last piece of approval that we would look for in the records to indicate that this was used for 3 dwellings. But there is something in there that indicates that there was possibly a multifamily dwelling license back in 2010. So we also have a letter from the Harlem Park Neighborhood Council, and they would agree to the use for 2 dwelling units, but not 3 at this particular location. So one of the difficulties is that we cannot verify that it had a lawful 3 dwelling unit use because there is no use and occupancy for this in city records, other than, as Mr. French stated, there was some indication that it was used for 3 dwelling units at some point in time, but we don't know if it was legal or not. In addition, that the board could, if it found that it was used as a multifamily dwelling, could reduce the number of units based on the variances that would be required. So the difficulty is here, we have no land use card, and we have basically the old housing inspection records that a housing inspector went in there and found 3 units in 2010. And that's what we have.
Okay. All right. Mr. Shitrick, can you speak to this property and its use, and more specifically, what evidence can you provide to us that demonstrates that it had a lawful prior multifamily use, 3 dwelling units?
Yes, this is Mr. Frank Gunner again. As you know, this property is on the corner of Edmondson Avenue and North Arlington. There is, on the Edmondson Avenue road, there's a side door as in addition to the front door. From my understanding of our survey of the existing property, there's a wall built and there's no access from the rear to the front. And from my understanding, that was the one of the existing apartments at the time. And then of course, and then in the front portion, there was the first floor apartment and then the upper floors. In the basement, there are existing 3 water meters as well as 3 gas meters. And that's what we have as far as evidence. Like, as you mentioned, we were not able to find legal documentation for these 3 units. But we do have photos of the meters that I mentioned, and in the provided existing plans, you can see the rear side door and then the wall that separates the front portions and as well as from the rear.
Okay.
So I think for this one, it's definitely a fact finding for the board. Is to, if you think he's provided enough information. The hard part is that we can't say one way or another. Like I said, we have an inspection report that there were 3 dwelling units in 2010, vacant building notice in 2013, so it hasn't been occupied since 2013.
Right, and the requirement, again, for the record, Ms. Byrne, the requirement to allow it to continue to be used as a multifamily dwelling is that there's been continuous use. Is that correct?
Yes. Well, yeah, under the old code, it said that, you know, you need to have some kind of proof for some kind of continual use, that the meters were there and continuing. And he can always ask for utility history from BG&E as well to prove that, you know, something happened. But the vacant building notice from 2013, that's problematic, because that says that there's been no use.
All right. Are there any questions of the applicant from the board? Otherwise,
I have one.
Go ahead, Bill.
Would you consider the neighborhood association's request or suggestion that you do 2 apartments or 2 units?
I would have to speak to my bosses and our, you know, accountants and everything. I'm not sure. I can't answer that at this time. I'm sorry.
All right. I'm sorry. This is Mr. Renner?
Yes. Yeah.
All right. Would it be helpful to you if you had additional time to search for and seek the evidence that the board is asking for to demonstrate lawful prior use and some continuous use in the face of the vacant building notice.
Yes, I would appreciate that.
You know, because I guess one of the things you risk, obviously, is the board ruling based on what's existing. Right now, it's before us, and that probably would not bode well. But to give you every opportunity and a full opportunity to present your information, you could agree to postpone this matter and regroup and give you an opportunity to present any additional evidence you might have.
Yes, thank you.
Is the board okay with that?
Yes, I'm fine.
Right, so we'll postpone case number 2021-102 to be reset. I guess, Mr. Renner, you can contact the office and confirm when you're ready to get back on the docket. Could be next docket or it could be after that. So we'll wait to hear from you.
Okay, thank you.
Okay, and I think that was all that you had, sir, for this docket, correct?
Yes, correct.
All right. We'll move on to case number 2021-134, 3003, the Alameda. The appellant is Ama Abura. This matter involves variance to bulk regulations regarding the use of the premises as 2 dwelling units. And I'll hear any reports we may have.
Thank you. Planning Department has reviewed this application, noted that this property is in the Coldstream Homestead Montebello Urban Renewal Plan area. Records available to the planning staff indicate that there were a series of construction permits issued during 2020, which appear to support work that would allow creation of 2 dwelling units in the premises. But there were no records available to planning staff showing a corresponding application for a use and occupancy permit for 2 dwelling units. And the records available also indicate that the last authorized use of the property is a single-family dwelling. As with one of the previous appeals, the issue here is that this particular property is located in the R6 zoning district, and the zoning code does not authorize conversion of single-family dwellings to multifamily dwellings in the R6 zoning district. For that reason, the Department of Planning is recommending disapproval of this application because the board is not authorized by the zoning code to approve conversion of a single-family dwelling to a multifamily dwelling in the R6 zoning district where this property is located.
Thank you, French.
Again, mirroring what Mr. French had to say, this property is an R6. Conversions are not allowed, period, in R6, whether by the board or the council. The Department of Housing and Community Development land use card stated that the last authorized use was as a single family dwelling. So this has only been a single family dwelling lawfully and according to city records. So can't really even get to the variances because the underlying use, the board doesn't have the authority to grant. So I will look for Ms. Abora. All right, we're going to go to call-in users. So if you are here for 2021-134-3003, the Alameda. Oh, forgot. In addition, we have a letter in opposition from the Coldstream Homestead Montebello Association, signed by Mark Washington, Executive Director, objecting to the attempted conversion from a single family to a multifamily. And now we'll go to the call-in users. Again, if you are here for 3003, the Alameda, please speak up when you hear the 2 beeps.
Hello.
Hello, is this Ms. Abora?
Yes. Yes, it is.
Okay, you sound very, very far away. I don't know what device you're on, but you can press something to so that we can hear you.
Can you hear us?
Okay, I can hear you now.
Okay.
All right.
I'm a husband of Amabura. I'm the one.
Okay, what's your name, sir? What is your name?
My name is Justus. I'm with you.
Can you spell that, please?
Justus, like a court justice. That's the first name, and the last name is Amoyesi.
Okay. Sir, could you and your wife hear and understand the commentary that was just stated regarding the history of this property being a single-family dwelling?
Yes, we hear that, but the property when we bought it, it's saying it's two dual units.
Well, what said it was 2 dwelling units?
When we bought it, it was 2 dwelling units, and it has 2 gas meter. The electricity meter is 2 meter. Everything was 2. And when we started the application too, we apply for application for each 2, and then the city didn't say anything to us that this unit has been 1 unit. They didn't. Anytime they ask, is it A or B, and we say, oh, both A and B. And we get a permit. We construct everything, the framing, everything 2-2. Right now, we spend a lot of money putting into a 2-unit dual unit, and so the occupancy permit. That's where we find. They said we have to get an occupancy permit that they deny us. So I don't understand it. If the 10 is not 2 unit, but they allow us to spend all this money, apply for permit, and since last year, permit issue it take us, and we're still now not anywhere.
Well, unfortunately, the reality is there are a number of folks out there who operate certain premises in violation of what the code requirements are. So the fact, one, that what you see physically are 2 units doesn't necessarily mean those are lawfully 2 units. We have not discerned, and doesn't appear to be any documentation in the record that demonstrates that this single-family home was lawfully turned into a multifamily. And secondly, along the way, if you're not approaching zoning to find out what the zoning history is and the requirements, I'm not sure that the whole process that you're doing otherwise and dealing with city officials is going to tell you, hey, you have a problem here. This is a single-family dwelling on paper and legally, and you can't convert that in this district to a multifamily dwelling. So it looks like you may have fallen into that gap where, again, it appears and operates the multifamily dwelling, but legally, the authority to do that was never granted. Ms. Burner, is there anything you can maybe add or express with regard to these other facets of communication with city folks, which did not raise a red flag to these folks?
When you purchase property, the first thing you have to do is check with the zoning administrator to see what the last legal use was. So just because when you come to a particular property and it looks like it's 2 units, doesn't necessarily mean that it is 2 units. And you are not the only person that has come before this board asking for multifamily when the last legal use was as 1 family. Those records lie with the Department of Housing and Community Development, and in particular the zoning administrator. So just because it looks like it can function that way doesn't mean it legally can function that way.
So given that state of affairs, to the extent the history that Ms. Byrne has reviewed and what's presented before us, to the extent that stands, again, because you are in an RA district, there's no ability now under the present code to convert that single family status to a multifamily status.
Yeah. Excuse me, sir.
Yes, sir.
So why when we start application, the city did approve for us to build, and we spent all this money, and they didn't tell us, hey, this is 1 unit, you can't do 2 units. But we apply for building permit, plumbing permit, electric permit, every 2. and they approve it for us to go ahead and do the burden. We spent all money to do everything to. And now we have to go ahead and dismantle everything, or how are we going to do it? The money that we put in all of that, and the city approved it for us to build. We don't know.
Well, that's the point. You don't know, and unfortunately, again, as Ms. Burns said, you may not be the only homeowner, property owner, who is subject to this, or maybe fell victim to it. But the entity that you must seek out is the zoning administrator and the zoning office to find out what the official, legal, valid, and authorized zoning is for the property. Those other agencies are busy doing what they normally do when you present the documentation. They themselves do not go back to zoning to cross-reference and check to see whether there's an authorized use that's being presented to them. But there is a particular agency, which is zoning, that you must come to. They don't do it for you. That's unfortunate.
Okay, sir. I agree what you're saying. So is it a law that you guys can do so that this doesn't keep happening? People spending money and then it gets waste, that they can attack if somebody getting a permit and the permit, it doesn't zoning doesn't approve to 2 units or 3 units, it doesn't keep happen, then the city just messing people up, that we don't have money that we don't have to spend, and then since 1 year that I started the project, I haven't get the job finished. And it's an empty houses that is in the Baltimore city. I believe most of them have my situation, that they're spending money that they don't have, and then in the middle of it, they cannot. They cannot go back and collect the whatever it turned into 1 unit, and the house still keep being empty. Instead of the department connecting all their data, that okay, if somebody come and get a permit, apply for permit for building permit, and they ask for 2 units, and the burden is not 2 units, we can find out that, hey, this is not 2 units, so we won't approve it in the first place, so that anybody won't spend money, a whole lot of money, do some work, and at the end of the day, it's waste. Why don't you
I understand your frustration, sir. All I can tell you is the agency that you must speak with and address before spending your money is zoning. And of course, not everyone does it. And again, you're not the first person, nor will you be the last to be subject to the rule and the design of the code. The problem that we're faced with, and I empathize with your plight and money spent, but this board is, again, to the extent that the records stand, and they appear to stand as a lawful operation of the premises as a single-family dwelling. The last lawful operation is as a single-family dwelling. We are without authority to grant the request that you're making. That's
okay.
all I can tell you.
Sir, can it be appealed? Can someone at least go there and see?
No, but it doesn't make a difference whether we see it, because.
And that was how we went ahead, and
ma'am, hold on. What we would expect to see is the 2 dwelling units that you're talking about. And the issue is not what it looks like and how the physical appearance of it. The issue for this board's authority is whether or not it is lawfully a multifamily dwelling. And we have no record of it lawfully being a multifamily dwelling. You can imagine that homeowners in the past, and not just with your property, have modified it to, generate income or do what they wish with the property, but everybody doesn't do it the right way and the lawful way. So it's incumbent upon, a new purchaser, to review all of the records. And one most important record is to go to the zoning office to identify what the zoning history of the property is before you expend your funds. And again, unfortunately, that didn't happen. But what that situation does, it deprives this board of authority to make a ruling, to grant it in your favor, because The code says we cannot. The code says there can be no conversions. And if it has been if it has been a single family dwelling lawfully, necessarily it would have to be converted legally to a multifamily. And under the present code, where that property resides, that is against the present law. So again, the board's hands are tied. Not saying whose fault that is. I'm just identifying to you what our position necessarily has to be, because we're without legal authority to grant this, even if we want to.
Yes, sir. We got what you're saying. I got it, but I don't want anybody to fall into that situation anymore, or either probably somebody already fall into that trap many times. So why don't Baltimore City have a data that connected to the zoning? It's the same housing. So they can find out that, okay, all right, if somebody applied for building permit and the building is 1 unit and the person is applying for 2 permits, no, we have to check for the zoning first, or the zoning doesn't say that. So they will disapprove or not approve for the person in order to the building permit, people will approve it, and then we apply for the plumbing, heating system, all of them. So all of them, they will approve it. And then when you get to occupancy permit, and then they know this is not. But the city, the zoning and the city permit, they are all one. But the data is not correct, and somebody just spending unnecessary money like that. But because the city is the one that approve it. And this pandemic time, we spent money and the time to do it. It's waste.
And it's just 2 years
all I'm saying is something that you guys can do as from today going, so that we don't keep falling into that. For me, I just came to the hearing that I heard that okay, if I'm buying a house, I have to go to the zoning and ask before. I didn't know that. It's not everybody know all the laws. There are certain things that you two don't know. So
that's true.
For you work there, so that's your work, so you know. But not everybody know that, especially I'm a foreigner. So I don't know every law laws that I hear that I have to go to the zoning before I buy the house. I didn't know that. We bought it,
sure,
and it didn't say that you have to go to the zoning before you get a house. So all I'm saying is, from today going, is it something that you can look into it? And I'll call and then follow up, see if you guys do that, because we don't want to keep falling into that trap that we have to spend unnecessary money.
Sure, and I appreciate. I fully understand your concern and your reaction to this reality. I can ask Ms. Byrne to speak to the issue of the separate agencies and again how they conduct business. But I guess what I'll leave you with is there are multiple agencies that one who is purchasing property and seeking to development should contact, and zoning clearly is one of them in a primary. So I'll leave you with that, Ms. Byrne. If there's anything you'd like to offer, please do.
Any kind of issues or challenges that you've had with permitting, I would recommend that you go back to the Department of Housing and Community Development, talk to the permit supervisor. In addition, always seek out the zoning administrator before you buy anything to find out what the last legally authorized use is. That's his job, right? That's one of the things that he does really well. He'll look all the records up for you and tell you what you can and cannot do with the property.
Yeah, but okay, we're also talking about the fact that they authorized it.
No, sir. What you got, sir, I'm going to step in right now. I understand exactly what you're saying. What you got was a construction permit. And when you apply for a construction permit to do work on a residential property, the last use was as a residential property. They're not going to look to see if it's 1 or 2. And I think that was the issue that you had. You needed to go to zoning first. So I understand what's happened to you. I understand your frustration. But always go to zoning before you pull a construction permit.
No, it's not even that. Our concern is why they approved it.
They approved because it's a residential dwelling. They never approved it for two. They never approved it for two. When you apply for construction permits.
Ma'am, we paid for it. There's proof, the email.
Sir,
BGE,
what I'm going to tell you to do is go back to the Department of Housing and Community Development. This group of people right here can't help you solve that problem.
That's where we are, folks.
So what you're saying is, so if we go there, can this problem be solved? Because we have invested money, and it's not like it's just we just separated it so that our
you have to ask them. You have to ask them. We can help you.
What we would suggest is that you go back to the folks you got the permits from, raise your issues there. The issue is you've come here for your relief. The relief that you need is for the zoning board to approve certain variances, which we can do if we are legally authorized to do that. Again, we all understand your frustration because we've been here before. When you say approved, hold on, stop. Let me finish. When you say approved, the critical issue that you need to understand is that it was not approved by zoning. When the other agencies are approving your permits, they're only looking to see that it's residential versus commercial, not whether or not there's a distinction between 1 unit, 2 units, 3 units, 4 units. So they will approve it if it's residential because that's what you're doing. You're getting a residential building permit, construction permit. That agency does not address the issue that is before you now, which is what is the lawful state of the property. Is it lawfully zoned as a single family or multifamily? That's the preeminent issue. It's a primary issue that, for anyone purchasing property and seeking to do anything with it, you need to know. You can only know that by going to zoning. Those other agencies won't do that for you. They will presume that you have gone to zoning, before you pull your permits or seek your construction permits. So that's where we are. We have heard, I think, sufficient information from you to know what the status of the property is. Board, are there any questions for the board? I don't anticipate there would be.
Yeah, my question is, if we go back to them.
No, the question is for the board, ma'am.
What can be done?
Question is for the board.
Back to you?
I will tell you that if you come back to this board, if you have the ability to do that, and you present the same circumstance, which I don't see a way that gets undone, then the result will be the same. We will still be without authority to grant the relief that you're asking for. There's not a mistake that anyone made. Pardon me?
Who has the authority to do that? Because now it's even going to cost us more to change it back after putting everything in it, putting the frame and putting the plumbing and everything. It's going to even cost us more to convert it back to.
I will tell you this:
so then,
once you get what you have to do first.
Due to the pandemic, we've been paying and we've lost so much money in this pandemic
ma'am,
that people have lost their jobs.
I've heard you. I know that you've lost money. That's your testimony, and you've gone out of your way to do this, in your view, the right way. You will get a resolution. Hold on. Ma'am, you will receive a ruling from this board. You will receive a ruling on your application here. There's obviously a reason that you're here and have filed an application because that's required. You will receive your resolution and decision. You have the right to appeal that decision. And so you can.
So if we appeal, are we?
I can't. I'm not going to predict any, ma'am. We're going to close this matter, but I can tell you that there's a process here. If we have legal authority to rule on something, we will. If we don't have legal authority to rule on something, we simply cannot. And the decision will be rendered accordingly. You have all the rights that are available to any other applicant if you disagree with the ruling that's made here, to appeal that to the Circuit Court for Baltimore City. What they will do, what they likely will do, or what they might do, I can't tell you that, and I can't predict percentage-wise or whether that's worth your time. That's a decision you have to make. But for the work and for the purposes of you being here, we will render a decision because we have a sufficient record by which to do so. We will issue a decision on your application. What you do with that decision will be up to you. We can't advise you, and that'll be up to you, and you control that. So with that, I think that we have a sufficient record before us on case number 2021-134, 3003, the Alameda, and we will close testimony for that matter. Thank you so much.
Okay. All right. So that testimony is closed.
Let me say something before we move on to the next one.
Sure.
This is obviously beyond our authority to grant that appeal. But I see no reason at all why the permit desk can't have a checklist and ask a person if they have gone to zoning.
Yeah, I looked
before issuing the permit. It doesn't make sense.
I think one of the issues here is I actually looked this permit up, and for the way that the permit system is that you can, for ease of permit, you can apply for your permits piecemeal. So if a permit applicant doesn't submit a plan that shows the design of the whole house, if they put in to upgrade the electrical panel, if they put in to upgrade the HVAC, if they put in to change all the doors, if they put in to change all the toilets, it never triggers going back. So that I agree with you 100%, Bill. There's definitely a process issue there, that I think to make things easier for people who are doing renovations a little bit at a time, and you don't need a general contractor and you don't need an architect, your trades just go ahead and put things in. You put in regular general construction permits, and it's not until the very end that you get your use and occupancy that all of a sudden it's a problem. And I think the system was designed to make the permitting easier for regular people, but then all of a sudden, like what you thought in your head you were doing, like the same two people never look at it. They never, until the very end, when that one person does that comprehensive look. And I don't have an answer for that, but I agree with you 100% that every single permit, if you don't put on your construction permit that it's 2 dwellings, it never gets caught if you're just doing upgrades.
But isn't there a way that we can kind of reach out to the other departments and just have them go through it with them from the beginning, even if they just give them a sheet of paper that tells them, if you are doing this for a multifamily dwelling, make sure that you check this first.
Yeah, and I think there are resources out there. They're just not necessarily readily available because you go through the permit process, and yeah, no, I mean it's definitely an issue. I don't know every single step of the process, but I know that e-permits was designed to be an easy access system so that you can get your permits quickly and things get turned over. And there's always an initial look. But if you don't identify on your permit ahead of time that you're doing 2 dwellings, then it never happens. But no, I agree with I mean, I think you guys have heard it enough that people get to the end and then they realize they have to come here. And I think it's just the way that the permits themselves are processed. So I think what was started to be an easy process ends up being really difficult for certain applicants.
It's probably inappropriate to even bring that up, but I think we should talk about it at another time.
Right, I agree, and I think it's something that we can raise in the general meeting discussion, and I think we can, as a board, you guys can choose to make a recommendation to DHCD, to transportation, to anybody, to the zoning administrator, to say that, like, this is what we've observed, and we can make that recommendation to those agencies.
Okay. To be continued.
Very well. Thank you, Ms. Byrne, for that background information.
Yeah, thanks, Jim.
So now we're going to turn our attention to the last remaining case on the docket, 2021-093, 606 Hyson Street. The appellant, Christian Clifton. Again, as we recall, this matter involved variances to bulk regulations related to the construction of a 2-story addition, rooftop deck, and rooftop stairway enclosure. I don't know that we need reports, but how about this? Ms. Byrne, could you just
Sure.
remind us where we've been and where we are present?
Absolutely. The original request was for a full lot coverage and 0 setbacks from the rear yard. What was proposed construction was basically an additional story to construct a 2-story addition, rooftop deck, rooftop stairway to an enclosure. There is no height variance per se because the height comes in underneath, but it's, you know, the overall design and character. Where we left was the applicant, Mr. Clifton, was going to speak with his neighbors, the Gisreels. The Gisreels had some ideas as to how the property could be modified. Mr. Clifton also went back to his architect to see how things could be modified. They did not ultimately have a meeting of the minds. What I sent to everyone on, I want to say it was either Friday or Monday, I can't recall now off the top of my head, was correspondence and new plans from Mr. Clifton and correspondence and proposed plans from the Gisreels. So what is still before this board is essentially a lot coverage variance and a setback variance. And again, variance standards are essentially to afford the property owner relief from certain regulations of the zoning code when unnecessary hardship or practical difficulty exists. Variance procedures here change to the bulk and yard regulations. And so the burden is on the applicant for the unnecessary hardship and practical difficulty. So I'll elevate Mr. Clifton to a panelist so he can update the board on his revised request and where things were left with his neighbors. And we have both the Gisreels and Mr. Harris, who is also a neighbor here who wants to testify in opposition. So, Mr. Clifton?
Yes, I'm here. Can you hear me?
Yes.
All right.
So I guess if you could update the board on your revised plan.
So originally I did have a squared lot. The lot is skewed in the back. So it's irregularly shaped and it actually starts to square off in my lot. So if you look, can you see the camera?
No, your camera is not on.
All right, I'm sorry, let me try this. All right.
Yes.
So you can see the corner is nipped from the lot.
Can you get it a little closer?
What are you showing us?
Just where the corner of the lot, my lot is actually nipped on the corner. So it's an irregular lot. It doesn't come back square 48 feet all the way through. It actually, the short point's 45 and it angles and then squares off from there. So anyway, that's why I modified the plans. Now, of course, I could still request full lot coverage, but it would be skewed on the back. 602 has done this. So 602, if you look at the back, this is the alleyway that we're talking about. They have actually taken full.
Can't see that.
Gotta bring it a little closer to the camera.
Yeah, I'm sorry. How's that?
Okay.
So this 602 has taken full lot coverage, and actually even taken the angle of the lot. So that carries into 604 and then 606, and then it squares off from there. Every other house on the block, except for the ones I'm getting opposition from, have taken either 100% lot coverage or close to. Here's an aerial view of Hyson. Can you see that?
I think I have that.
Yeah, I think everybody should have that in their packet. Go ahead.
602 has taken full lot coverage. It steps in because they have a basement stairwell or stairway leading out. Then we have the 3 that are in discussion, which have not. Mine been in the middle of those 3. And then 610 through 618, again, have all taken full lot coverage or close to, over 95%. So the only thing I'm asking for is to do what's consistent with the block. that's pretty much it. I know they have opposition, and I'll just discuss what what their issues are after.
Mr. Christian, I'm sorry, Clifton, I was muted, unfortunately. The photo that you just had, which was the aerial view, can you pull that up again?
Yeah, absolutely. And I even have them numbered. So here's 602. 604 through 608 are the only ones that still set in. And then 610 through 618 all go out. Most of them have full lot coverage, starts on the second floor, and they have like a 2-foot setback on the basement. So mine would have a 3.5 foot setback on the long point and a 6-inch setback on the short point, because it is a skewed lot. So I figured it would be 95% lot coverage if you add the skewed back up and then multiply where my proposed addition would end. And I'm sorry, Kathleen.
Mm-hmm.
Yesterday you actually asked if it was still 30 feet for the height.
Yes.
On the drawing, it actually shows it to be right at about 24, so it's not quite 30. Because the basement actually is below grade. So every basement on this block has an exterior door that exits out with a few steps. So it'll be right around 25 feet from the back grade. I don't know if you're considering the front or the back, but I know the back's in question. So it will be less than the 30 that we discussed. Also, I'd like to talk about, I think it was Robert emailed and saying that his proposed plans only eliminated one of the bathrooms, which is not correct at all. I had a laundry room upstairs as well in the basement. I'm more than willing to eliminate the basement laundry, but most people prefer to have a laundry on the floor that they occupy. He downsized the bedrooms to 10 by 10. The basement bedroom would actually be 9.5 by 10.4, which, if anyone is familiar with that, is a tiny bedroom. He eliminated my straight stairs, and he wanted winders, which most people know is very difficult to move larger furniture. He doesn't want me to build to my property line, the 12 feet, the width. He said he wants me to stay 3 to 4 inches inside of my property line, which is only 12 feet, so that creates issues sometimes. He doesn't want me to have my rooftop shown in my plans. He wants me to put sleepers and drop the height of my rooftop to basically lay on the roof, which I don't know how that affects him. He also said if I wasn't willing to do any of this, or all of this rather, that he would make it hell on me. That was his words throughout this process. And that he would also have Ben post signs saying that I could have no access to the yard, to waterproof the side of my house, which is difficult without accessing the neighboring yards. I mean, I figured out a way to do that, but so after I had that conversation with him, I'm not even willing to try to negotiate with him at this time. And that was his exact words. He said he would make it hell on me if I didn't do exactly what they proposed.
Okay. That's go ahead.
No, go ahead. I just want to make sure that that's everything that he had. So.
Right. Does anyone have any questions? Anyone have any questions for Mr. Clifton?
Not at this time.
Right.
I have one more comment.
Go ahead.
The rooftop deck, he said had to be fire rated, which I disagreed. So he wanted me to put, on his drawing, I think it proposes that I have, rather than an open rail, a 3-foot firewall. So I told him that was not required by code, that it had to be inside the building envelope and 4 foot from the property line had to be fire rated, which of course we would do. And if that was the case, that every rooftop deck in Baltimore City would be in violation of this. And he said that was incorrect. He has a good friend that's a fire chief, and told him that eventually all of Baltimore City would burn to the ground because of this. So this is what I'm dealing with the neighbors.
Right. Who else do we have, Ms. Bird?
We have the Gizriels and we have Mr. Harris. So we'll start with the Gizriels. So Mr. Clifton, I'm going to go ahead and mute you. You'll have the last word. All right. Ms. Gizriel, you're unmuted.
Thank you. I just have a few things to say. We went to meet with Chris to see if he was willing to modify any of the plans that he had. And we suggested one less bedroom. We suggested moving the laundry room downstairs. We suggested reducing one bathroom, which would shorten the distance that the setback required. We came up with a complete new design to show that you could still have 2 bedrooms, 2 baths, or even 3 bedrooms, 2 baths within approximate 80-foot lot coverage. And he really wasn't willing to change any of his plan. So it's a plan that he's used in other flips that he's done. And perhaps they haven't been as small a lot as this, but this is basically a tight community of 1 bedroom, 1 bath homes originally, maybe not even a bathroom originally, but you know what I'm saying. They're small 1900 built lots with 1 bedroom, 1 bath originally. And the plan that we came up with gave 3 bedrooms and 2 baths, which I thought was very reasonable, and filled what he called a bonus room with the laundry area for the full house. So I think we presented as best we could. We didn't get any feedback in favor of making any modifications at all. So basically it's going to present a close to 30-foot wall next to the 604 property, which I own, which would only give me a 6-inch setback. And on the opposite side of that, at the 608 property, it'd only give a 3.5 foot setback. I think that's going to have a major impact on the light and air in my property. And it's really an unnecessary hardship on the property because I think there's an alternative way to design this that would still provide, in this booming real estate market, his opportunity to flip this for a profit. And my husband's here today. I think he has a couple of comments to make on the site plan and the block.
Okay. Hello, good afternoon. I'm an architect. I've been in practice for over 40 years. I started with the Dollar House program in Berry Circle, working for a design build outfit. I did a house for myself in Federal Hill. I homesteaded. It was a 12-foot wide house, very similar to this. And I've done a number of these over the years. I pretty much concentrated my practice in renovation, whether it's residential or commercial. But I guess the main issue is the site plan. So I did a site plan showing that the neighbors on Harvey Street basically have an 8 or 7'6" setback to an addition, and it's less than that to a exterior stairs that goes up to the deck. So if you add their setback and then the alley and then his 6-inch setback, you really only have 13 feet from the edge of his building to the edge of the other frame building on Harvey Street, which really is very dangerous. You can see the whole area has a lot of these houses that all they have is a 5-foot alley. So if any time there was a fire, it would be very difficult for the fire department to find this. So my coming back just 10 foot 6 inches will leave a 20-foot setback from our across the alleyway from our framed addition to an existing framed addition, which I think would be the best we could come up with at this time. Most properties that you grant a a variance on lot coverage has a 20 or 30-foot alley, and this really has a 5-foot alley, so it's a really different situation. Also, when he talked about I originally talked to him and he said he was going to use the original foundation that's there. So this is a photograph of the foundation that's there now that he's going to, so that is Ben's, that's 608, while this one is ours. So you could see this foundation is 3 to 6 inches from these fences. So what I said to him is, how can you build a fire-rated frame wall? I said, it's better to just come up at least the basement level with an 8-inch block wall. And then above that, you can go to a frame wall. And we would willing to compromise and take down our fences so he could then, you'd have to pretty much stand on our property to finish his walls. If he didn't agree to that, then I would restrict access to our property. And that's where he thought that was really nasty. I guess the other issue is, if you look at my scheme of my second floor, really you see I have a nice bedroom in the front. Actually, it's bigger than I thought. It'll be 12 by 11. And then the addition in the back is 10.6 by, so it's a 6-inch wall. It's basically 10.4 by, like you said, 9.5. So we feel we're trying to be as reasonable as possible we want the building renovated. We don't like it as it is. But the other feature of his property that he talked about, how his building is only 24 feet. Well, if you do the math on his drawing, the building alone is 27 feet. Then you add a deck. So his deck is 8 inches above the roof, then a 2 by 12, another 8. So with the railing, it adds another 5 feet 4 inches. So the actual height of this whole property is going to be 32 feet 4 inches if you do the math. But this is an undue hardship on either property on either side. Thank you.
I think that's the end for us. Thank you, Kathleen.
Can I ask a question, please?
Sure, Bill, go ahead.
Could you very quickly remind us of your points of opposition to the original plan?
The points of opposition is that we have, we'll be surrounded with a 32-foot height wall. That's on our property and their Ben's property. So what that'll do, the light and air to us will really restrict us and restrict the quality of life to anybody living there.
We're basically opposed to the full lot coverage. We were, the revised plan that my husband did gave a setback of like 7 feet.
I've got it. Thank you.
Okay.
I didn't hear that.
What?
I think he understands your response.
Yeah.
Okay, then what I'll do is, Mr. Miskizzer, I'm going to just mute you, and then I'm going to put Mr. Harris on. Mr. Harris?
Hey, good afternoon, everybody. I support the renovation of 606 Hyson Street. I don't support the full lot coverage. I don't support.
Mr. Harris, I'm going to ask you to start over. I can't hear you, sir.
Sorry. I want to say that I support a renovation at 606 Hyson. It's badly needed. I don't support full lot coverage. I don't believe that it is the character of the neighborhood. Every single house behind on Harvey Street has not done full lot coverage. I have not. The Gizraels have not. Just because some other houses have been built that way doesn't mean that defines the character of the block. I believe there's room for compromise in here that doesn't provide, a 30-foot wall that's extending 25, 30 feet past the end of my house that would pretty much deprive the rear of my property of all sunlight and the flow of air. And to Mr. Clifton's comments about Mr. Gisrael saying that I would be posting signs and stuff like that, I've never had that conversation with anybody, so I don't know the first thing about that. I want to work with Mr. Clifton to find a compromise. I don't believe that somebody should buy a property and need every ordinance exempted in order for them to have a profitable project. If he bought the property, he should have been able to figure out a way to make a profitable project under current zoning laws. I don't think exemptions are necessary for, 100% lot coverage and everything that he's trying to do. That's pretty much all I have to say. I support a compromise. I think what the Gisrael offered is a good step in the right direction. So I want to continue working together with Mr. Clifton and hope to find something that'll work.
Okay, are we then back to Mr. Clifton? Muted, Katie.
Sorry about that. All right, so we've got, looks like we have 2 call-in users, so I'm just gonna go through the call-in users just to make sure. Well, actually, I think we have 1 because I know the first call-in user, so we're gonna go to the second call-in user. And if you are here for 606 Hyson Street, please speak up.
Okay, now if I knew that when I was a kid.
Nope. So that would be it for call-in users. If there's anybody else here that wishes to testify on Hyson Street, if you could please raise your hand or put in the chat. And let me see. So I don't see anyone else. So now we will go to Mr. Clifton. And Mr. Clifton, you're unmuted.
All right, so I just met with the Gisrael Saturday, so I don't think they had a conversation with Ben about posting a sign, but it was mentioned. I didn't say that they spoke with him. I'm adding the numbers up. I mean, she has 710, 810, and 8 for the heights. I did not include the roof deck for the final height. I didn't know that should be included because it's an open space. But I'm coming up with 25. Again, I'm only asking what's consistent in the neighborhood. I realize that Harvey is behind us, but we're discussing Hyson, and every house on Hyson has been granted what I'm asking to do, except for the train discussion. So this is the first time that I've asked for full lot coverage. I've been to variances before, but I've had enough. I mean, I'd be more than willing, even if I had 55 feet to step back and have 10 feet or whatever was required. But if you look at the floor plan, it just doesn't work. Again, I discussed his proposals. I can go over them again, but I've already went over those. They don't work. 602 and 614 have both been listed within the last 8 months and taken off the market. There's no street parking, which is a deterrent for most. If you live in Fed Hill, you would realize that 95% of the time when you get home, you don't find parking in front of your house anyway. But there's somebody unknowing of that, it's a deterrent. So I don't want to start backing off, more and more things to not be able to sell the house. As far as I know, there's only 2 owner occupants on this street. So I'm trying to bring another owner occupant in. I'm trying to do something that's appealing. I'm definitely not trying to overbuild. It's just the size of the lot. I can't figure anything else. I mean, I'm not in favor of anything Mr. Gisrael's done. It's nothing against him personally. It's just the room sizes, the stair layout, the elimination of the laundry, the elimination of the bathroom. I'd have a tub upstairs, which most people want to shower. It's all things that I don't think are appealing to a buyer. So again, if it was any way possible to do it and have an 8-foot or 10-foot setback, I'd be more than willing to do that. It's just I don't have the space on this lot. When I bought the house, I looked at what was consistent in that block, and that's what they have. I mean, it's like I said, it's only 3 houses that do not have full lot coverage or close to, and I believe it's because of the size of the lot that, you know, that they asked for it and were granted close to full lot coverage. So that's all I have to say. Thank you.
Okay. Let me just ask one final question to Mr. Clifton.
Yep.
So if you're asked what's the, you believe your property is unique because of the reasons you've stated, the things that you've testified to both previously and today?
Do I think that my what?
The property is unique.
Compared to what?
Well, that's what I'm asking you.
I mean, it's definitely a small lot. You know, in order to get what I would, I mean, I'm sure they object, but what I would consider a appealing house or appealing layout, it's a unique lot. I mean, most of every other lot that I've done, except for one on Fleet Street in Fells, where they had already taken full lot coverage, have been way bigger than this. So yeah, it's definitely a unique lot.
And would you say that the hardship, if any, that you face with regard to is there a hardship that requires you to have these variances?
Oh, absolutely. Those house size, it's 27.5 feet. The stairs currently go side to side. So it's just, the layout currently would not work. And then the addition, in order to, I mean, even the proposed bedrooms I have are tiny. I mean, I think they're 11 feet. Some's 12 feet. But his, I mean, some of the bedrooms are 9.5 feet. That's basically an office. He actually has bedroom / office on the bedroom sizes. So it's a unique lot.
Okay, that's all the questions I have for the applicant. I think this will conclude the testimony for 606 Hyson.
Thank you.
And we'll take it up in deliberations.
Okay. All right. So I'm gonna change the status of all of those from presenters to attendees, and I think that is the last. That's the last one we had.
All right, very well.